All right, Ms. Pereira, I'm sorry. I'm interrupting you. I apologize, but I have some questions and I need to put them to you.
As it pleases the court, my lord, I'm more than happy to answer them to the best.
Live from the
You're welcome
capital,
to sit down.
this is
My office
IPHC
stands.
Media.
My lord,
As we provide you with special insights, stay with us for the special live coverage streaming live from the North Gauteng High Court.
because of the three factions that now exists,
This is the International Pentecost Holiness Church live broadcast.
by each of these first to third respondents on their own accord, without the correct procedure. Done. Each of the respondents say they have not produced proof in this regard. And that's why we are saying, let's stop them from acting in the way that they are acting and get to the point of having a real successor or the correct successor.
Let's say for argument's sake I'm with you and you get an interdict that they're not allowed to call themselves the comforter or hold themselves out to be and assume that role within the church. Where does it take you practically?
My lord, my submission in that regard would be that if anything is done in this church, the entire congregation is included. Whether it
Happen in secret and in
Indeed, my
dark
lord,
passages,
and
no.
now we're sitting with three comforters that all claiming that
resolved. I'm just not sure that what you are is the right path. Let me ask you this. The church's finances are apparently safeguarded by the fact that the accounts have been frozen.
By Standard Bank.
Okay, so there's no financial implication. There's no irreparable harm relating to finances.
At that point, we do not know what has happened to the finances of the church in between the freezing and now.
Yeah. Well, in order for you to obtain an interdict, you have to show me that you've got at least a prima facie right to the order that you're looking for.
Indeed, my lord.
Okay. Even though I might have some doubt about it, if you do have a prima facie right, you're in that then, and you can show irreparable harm, the likelihood of irreparable harm, and that you've got no other alternative but to the remedy that you're asking me to provide, and that the balance of convenience favors you. You've got to jump over all 4 of those hurdles if you only show a prima facie right, which it seems to me is here. I'm not saying it is a prima facie right, I'm saying at the best for you, that is what you have. So you have to jump over all 4 of those hurdles. Right, so what is the irreparable harm to your clients?
My lord, if I may start... My lord, if I may start with the prima facie right and then go through each element if I'm satisfied with that. My lord, there are 2 interrelated rights that the applicant relies on, and the first is the rights as members, and then the first applicant is the church under the 2007 Constitution. The second right...
Sorry, just say that again.
So the rights as members...
Yes.
And as the priest, as the first applicant is a priest,
yes,
in terms of the 2007 Constitution. So they form members of his church. That brings them a first right to approach for intervention when same is required, my lord. And then secondly, the right to religious association and dignity under our own South African Constitution, my lord. The claim is not and has never been to appoint a new comforter. The claim is that the church should function in accordance with its own governing 2007 Constitution, which it is not currently doing, and that it should be free from competing unlawful assertions of authority, which is then that authority being the first to the third respondents. So I'm saying its prima facie right is that the fourth respondent ought to operate within its own constitution, and the intention of that constitution should be exercised as how it was always intended to. And that hasn't been done. And it has become simply impossible to deal with this internally, as we have seen from a multitude of case law, but that is how the court prefers for especially religious matters, is that you should first exhaust all internal remedies available to you and then approach the court for intervention.
Was it harm to a third party like the church?
My lord, it's interrelated, we're saying here, because it is aid to the church because unlawful procedures were followed in terms of the comforters that have now just appointed themselves, and to its members. Because of how procedures were followed, the members now have to choose between factions. There is consequences to determining I want to be this or that faction, and at times that has resulted in violent situations, intimidating situations, my lord. And the members need not have been ever exposed to that. I do not know if that answers your question, my lord. My lord, if I may just have a second to get to
really, Ms. Pereira, but anyway, I understand your submission.
Thank you, my lord. My lord, so in essence, and my lord would have noted that from paragraph 108 of my heads of argument, which is page 052-36, is that relies on the Constitution of South Africa and of the Church has then determined or has established the prima facie right that the applicants are determining.
Is there common cause that the 2007 Constitution is the governing document for the Church?
My Lord, as far as my recollection go, that is indeed the fact, is the case, my Lord.
Right, I'll hear from Mr. Osborne.
That is indeed the case for my clients. My understanding is that it's not the case with respect to the
Third respondent. All right, I'll hear from Mr. Mpilo then. Thank you. Ms. Barrera, it seems that you and Mr. Osborne have unanimity, but Mr. Mpilo differs from you.
My Lord, may I proceed or do you first?
Yes, no, carry on.
As it pleases the court.
I'll hear from Mr. Mpilo just now. So it's common cause between
the applicants, the first and the fourth respondent, my Lord.
Does that Constitution, the 2007 Constitution, at all prescribe how membership is terminated?
No, my Lord.
I didn't see it.
No, my Lord. My Lord, if I may have the opportunity to just read you exactly what it says there in terms of membership.
I think it's one paragraph.
It's 3 small paragraphs, my Lord. And that is paragraph 13 of the 2007 reads membership 13.1.
What is the page there, please, Miss?
My Lord, that is under 006-108, my Lord. It is more or less in the middle of a page.
Yes, I saw.
13.1 reads, a person who has been healed and has attended healing sessions has the choice of becoming a member and being a witness of such healing. 13.2, a person by becoming a member accepts the statement of faith and the objectives of the church. And 13.3, a church member is subjected to the disciplinary measures of the church. But nowhere does it speak of termination of membership, or you automatically lose your membership if you don't attend services or a certain amount of services or haven't been to church for a certain period of time, my Lord, as it pleases the court.
Thank you.
So, my Lord, the essence of the applicant's prima facie right also stems to their right to worship and minister in a church whose governance is conducted in accordance with this church's 2007 Constitution, which right has been violated by active members of this church, or members that was active at this time. And we know that the priest, the first applicant, is still an active member in Namibia. My Lord, the applicants at no point is asking this court to restrict them from actually the first, second, or third respondents in order for a new comforter to be appointed. We are merely saying, let's go back to basics and get a process to get a comforter that should be leading this church. There's nothing we can do about the fact that the late Comforter Modise did not appoint a successor, but we now have to deal with the consequences thereof. It was never properly dealt with. There were claims made that it is properly dealt with because I have a video and a will, but it was never produced. And that is where that stems from, my Lord. My Lord, I have highlighted certain case law in my case of arguments, which I know my Lord has had regard for. Then we get to the element of an interim interdict of irreparable harm, which, my Lord, the harm arises from the ongoing conflict between leadership in this church. And that relates directly to the fact that we are sitting with 3 factions and 3 comforters. The fact that the other 2 respondents has smaller factions within the church does not negate that it is still one church that is split. A majority and minority faction does not matter in this instance, my lord, because we should be one faction. We should be one church, and that is not the case. Bring us back to the basics within the lines of our constitution. Let the EXCO find a way forward, is what we are saying. My lord, multiple individuals are constantly and simultaneously claiming they have special religious authority and they have been selected to guide and lead these institutions, which has ultimately resulted in institutional instability and conflict, constant and continuous conflict for the last 10 years, because that is essentially how long.
It's very unfortunate, Ms. Barrera.
Indeed, my lord, and this was a very, very strong
And it is a church. It's supposed to be united.
Indeed, my lord, and having this instability was actually from the start completely preventable if the right actions were taken. But the applicants are sitting with a position where it has deemed that it has no other remedy other than seeking an interim interdict.
Well, what could have been done, Ms. Barrera? Let's assume that the late comforter did not appoint somebody. What should have happened then?
My lord, the EXCO ought to have stepped up.
But why doesn't the EXCO step up now?
My lord, I am not acting on their behalf and I can unfortunately not make submissions in that regard. But we are now sitting with members that are saying it cannot go on like this. Please do something. Help us get our church back to the glory it ought to be in, my lord.
Yes.
As it pleases the court. My lord, the founding affidavit sets up various instances and incidents of division and disputes over the different branches of the church, the properties, and then the leadership structures, which forms part of irreparable harm. You are sitting with members that, and I've said this multiple times, my lord, and I do apologize for repeating myself, but you're sitting with members that don't know where they belong. It leaves them in a position where we are part of this church, but we are not active and participating as we want to because we do not know where we belong. And my lord, that goes back, and once one has a spiritual and religious connection and you belong and you believe that your soul has to go somewhere. And my question arose, and I did discuss this with my clients, is where does your soul go if you do not go in a faction? And you wholeheartedly believe in that, but I will not take that any further. But my lord, what I'm saying is that the irreparable harm stems to A, the standing of this church within the community it used to be, because dividing it in 3 factions has most definitely caused irreparable harm. And B, the irreparable harm caused to those members who were part of a church who knew where they belonged. This church, my lord would have noted from the constitution, has a very clear structure. We sit with the comforter, who forms part of the EXCO, then the elders, and then the youth members, and then the normal congregation. I was now part of the elders, but I don't believe in these factions, and I don't think how things were done correctly because there was no succession. Now where do I belong? I no longer sit with the elders because I am not part of them anymore, but I'm still part of the church. Where do I belong? Where does my soul belong, my lord? And that is the basis of the irreparable harm. We come to this court asking for this interim interdict so that this can be resolved. My lord, I can guarantee you right now that...
Let's say you get an interdict. What would be the practical effect of it? So now the Medices and Mr. Sandlana are not allowed to call themselves comforters, but what next?
My lord, the EXCO will have to come together, and whether there's a new or amended constitution to determine how are we going to select or elect rather a comforter is what the EXCO will have to determine. Whether they then decide we need more members of the EXCO, we need to get the elders involved, that the EXCO will know. They know the intricate dealings of this church way better than my lord and I will ever understand. But at the end of the day, the EXCO remains and they are all priests, as my understanding go, my lord, they remain the top body, the governing rather the governing body of his church, my lord. And they need to step in and say, let's get this back to where we're supposed to be. We agree there cannot be 3 comforters. Because the other question is, we have 3 factions. Does all 3 factions follow the same constitution? Does all 3 factions rely on the same principle that this church, the cornerstones of this church? And we need to restrain that, because in the event that there are violence and intimidation from any of these factions towards another faction, that breaks down the essence of any church, my lord, irreparably harming members, as well as the reputation and the good standing of such a church. Lord, for an extended amount of time, the bank accounts had to be frozen, which is a good thing. However, what harm has that caused to members of this church that was dependent on that, whether that be for charity projects or for children's homes or for elderly homes, we don't know. But the fact remains that even there remains the financial part of it also contributes to the irreparable harm caused in this matter, my lord. My lord, Judge Colopin, in my understanding and of her order, tried to guide this church.
It's a male.
I apologize.
That's okay. I think your colleague, Miss Colopin, is his daughter.
As the pleases the court, my
Okay.
lord. Justice Colopin tried to guide this church to get to a point where perhaps the intention was for comforters to be selected, but there obviously was not enough detail to say that A, B, C, D, E, F, G, this is your objective.
No, look, look, a lot of your notice of motion is a duplication of what Judge Colopin's already ordered.
Indeed, my lord.
So, can we just have a look at it if you don't mind? Paragraph 1.3, the day-to-day management activities of the IPHC will vest in the executive committee. He already ordered that 10 years ago.
Indeed, my lord.
And that's what's been happening since, I believe.
Not completely is my understanding, but I will take instruction on that, my
Okay.
lord. There has been,
The same with 1.4. It's a repetition of what Judge Colopin ordered 10 years ago.
indeed, my lord.
Now you say that in paragraph 2, the executive committee must now take steps to call a special general meeting in terms of clause 18. What then? The Constitution doesn't allow for the executive committee to appoint a comforter.
But the executive committee has the ability to amend the constitution.
No, they can only do that if they consult with all of the membership.
Indeed, my lord, but none
As
of
I
the-
understand it, am I wrong?
No, you are not wrong, my lord, but to get to a point of amending and incorporating anything in respect of the appointment of a successor, one has to confer that, or one has to agree, rather, that that is the EXCO's position in this matter. They need to sit and say, appointing a successor needs to happen A, B, and C. This is how we do it. Present it to the members of the church, the congregation, and say, here's a vote on it. But right now, nothing.
But you see, none of this is affected by the order that you're looking for from me. The order that you want won't remedy your problem. Am I wrong, Ms. Pereira?
My lord, my submission in that regard can only be that my order is seeking a broad, for the expert to essentially take control. We have not
But
specified
it
A, B, and C.
has control, Ms. Pereira. Sorry to interrupt you, but it has control.
My lord,
Since the Judge Colopin's order in 2016. You want to take an instruction?
as it is important. My lord, my instructing attorney and has indicated to me, and that is also clear in our papers, is in that first meeting that led to the election, the first applicant was elected onto the EXCO,
Yes.
but nothing after that followed as it should have been. Steps were taken that him as an EXCO member was not even aware of, which included the appointment of Mr. Sandlala as the comforter of the biggest faction of the fourth respondent.
So was Mr. Sandlana's appointment as comforter accepted by the EXCO?
Yes, my lord. However, we are saying that the processes weren't followed properly. The first applicant, that was a member of that EXCO, was not even aware of the fact that he's being introduced or being put up as a successor. There was no opportunity for him to say anything. It just
I
happened.
seem to recall there was an EXCO meeting called in, was it November of 2016, 17, round about there, where your client elected not to go. And I accept his reasons, but he elected not to go.
As a police support
Isn't that so?
group. And then the election occurred on the 4th of February 2018, if I'm not mistaken.
Yeah, I think you're right.
My lord, but essentially, he elected to not go that one time, and then after that he was excluded from anything further from the EXCO. So electing not to go versus no longer being an EXCO member is two vastly different concepts, my lord. You cannot just
I hear
exclude
what
an
you're saying.
EXCO member because he did not attend once, or elected not to attend once. He did not terminate or give up his position in the executive committee, my lord.
Yes.
And we are saying that the EXCO needs to be looked at, and they need to revise their processes because it was not done correctly, my lord. And that is essentially linked straight to the irreparable harm not only suffered by the first applicant, but the rest of the applicants, as well as members of his church, which I can guarantee, my lord, we have not cited in this matter, because having a million or a hell of a lot of applicants would make these papers, the header would be extensive. Lord, the balance of convenience then goes to the applicants are seeking one thing and one thing only: interim stabilization of this church. And that relates to one faction, one church, one unity. My lord, in the event that an interdict is granted, none of the respondents will be prejudiced. In fact, the converse is true, because we will be united as one church again once the EXCO actually take control, as they ought to have done when Comforter Modisa passed away. If that was dealt with correctly, there would never have been a split in factions by two legitimate and one illegitimate brother. We would sit with one church. We would not sit with one church, three factions, violence, intimidation, and all of that has ensued since the factions have been created. My lord, it would be to the benefit of his church restraining the other comforters, or the comforters, and essentially the operation of three factions. Because, as I've now stated, we will become one again, my lord. And that has to be the main objective of a church like the fourth respondent. And that is the main objective that the applicants are trying to achieve with this interim interdict. My lord, in the event that the interdict is not granted, it will leave us in a position where the existing instability and the fact that there's three factions and we're sitting with members where they don't know where they belong or what their role is, or actually just do they belong, will persist. The instability will persist. The matters, there are several court matters, as my lord have now heard, that will carry on. My lord would have noted that there is also a contempt of court application that is ongoing against the second and third respondent, as far as my knowledge go. I do not know the intricate details, and I don't care.
It's the first I've heard of it, yeah.
But my lord, it's in my colleague's heads of arguments.
Ah,
But
okay.
in essence, we are merely looking for a situation where the EXCO is placed in a position or is tasked with selecting or electing and determining the rightful comforter, for lack of better words. Because that is what this church needs, is the rightful comforter to bring them together again, to be one faction again, my lord.
Yeah. I hear what you're saying, Ms. Barrera. It's a terrible situation. It needs to be resolved. I fully agree with you. I'm just not sure that this, what you're proposing is the right way.
My Lord, the relief that the applicant seeks is, in their opinion, the only way as to how we are going to get to a solution. And that is premised on the fact that there's so much instability. And I've asked this previously and I'll ask it again, my Lord. How do we get 3 comforters to sit together? We don't know. Is there 3 different executives, excos? Is it one constitution between amongst all these factions? How do we sit with 3 comforters and 3 just relinquish their powers as the comforters? Essentially, the exco has to come together and determine that this is how it's going to work. This is how its succession works. In the event that you don't want to form part of this, go form your own church. But you cannot be part of the Fourth Respondents Church because you are damaging us. You are not part of our values, not part of our value. You're not part of what our Constitution set us out to be. We need to become, this church needs to come back to one, my Lord. And that is the essence of...
I've acknowledged that I'm with you on that sentiment completely.
My Lord. And as I've now stated, the only relief that the applicants could see is this way forward. Getting an interim interdict by stopping all 3, the alleged comforters. Placing the power back into the exco's hand and say, make us one, like we ought to be, and as it is intended for us to be from the start. My Lord, yes,
anything else?
My Lord, just in terms of the no adequate remedy, the internal structures of the church, I've addressed this previously, there's been the inability exists for the resolving of this dispute within the church structure itself, and one can probably attribute to the fact that there are several factions and none wants to relinquish any power in this regard. My Lord, and on that basis, the court is approached as the competent and the correct forum that is capable and able of helping us as the applicants to preserve the governance and the essence of this church. My Lord, that is my address. There are several points in limine that my colleagues will have to address, which I will then respond to once I have done so.
Can I ask you this?
Yes, my Lord.
Even if you get over all 4 hurdles, I still have a discretion as to whether to grant the order or not. Is that right? You agree?
Indeed, my Lord.
And there's ample authority that one of the issues that I need to look at is if there's been an undue delay in bringing the application. Now, it's been 7 years, I think, 8 years maybe, since this dispute arose. Why now? Why do you bring the application now, 8 years later?
My Lord, there has been a multitude, from my understanding, a multitude of attempts to resolve this issue within the church. And once these members realized that this really is genuinely going nowhere, they did approach this court. They realized
Is that in your papers?
My Lord, the instability is in our papers, and the instability relates to, they realized the instability is going nowhere unless there's intervention. And on that basis, the members then got together that, unfortunately, it's the members that feel like they don't belong in either of the factions, they want one faction, then approach this court for relief, my Lord.
Right, thank you.
As it pleases the court.
Mr. Osborne, I see it's nearly tea time. Shall we take a break until past?
As it pleases.
All right, thank you. We're adjourned.
All right.
What's all? Yep. What is it? You see, I'm marking at Amara. I just don't do I'm cup. Let me see. Live up friendship. Yung tapo kanan. Let me see. Chairman, yeah, my do up what you want. I think, yeah. I'm saying. Okay. Yeah, okay. Yeah, come on. Let's see. You love a media. Oh.
Yo pick up.
Alright, sorry.
Thopella go tla re nyaka ya are mole re kopane mole wa le nyaka mole kwa go tafole mo are mole teng
depth and breadth of the Southern Development Community, SADC, and to the South Africans in general. We are here today at the South Gauteng, the North Gauteng High Court in Pretoria. We are here for two cases. The first case is the eviction case, which unfortunately is not taking place as we speak. But there's another case that relates to a delayed and a later dispute by a group of individuals who thought they are smart and clever after 8 years, especially when the permanent withdrawal of the two brothers of the leadership case happened. And then they enrolled in the case to say they have a dispute around that leadership issue. So as we speak, the court is on break right now, and they are busy arguing as to why they think and they believe that the leadership issue must continue. But as we can say, we can tell you right now that they have no case, but the argument are still on. And just tune in on our YouTube channel so that you can see yourself and basically witness yourself what the arguments are. Be that as it may, there are so many issues that are outstanding. Do not be fooled by the fact that the issues around IPHC relating to the factions that I play at the moment, it's over. It's not over. There's an eviction issue. There's an issue about Standard Bank. People stole money. The thieves stole money, Standard Bank. We managed to freeze that account. That's the issue that is outstanding. And there's an issue of declaratory order around rules, the challenge of authority that needs to take place. There's contempt of court that because people withdrew permanently from the case, but they are still continuing to call themselves comforters. So there's a contempt case against those two brothers who continue to call themselves the comforters while they know that they are not the comforters. So where we are in court at the moment, we are going to go back and argue around what are these people saying around the leadership, but they are a complete non-entities. They don't know what they are saying, and they need to say why are they coming after 8 years. So we're going to go back in court right now because we are going back to take the feed live. So just tune in. We'll give you another update when the court goes to lunch or when the court ends. Thank you.
We agree. My understanding from the papers for the third respondent is that they not agree. They say that there are articles of association creating an NPC which supersedes this 2007 constitution. But we'll learn, or that may or may not be confirmed by my learned friend for the third respondent. In any event, that's a prayer. A second prayer reflected at paragraph 13. An order declaring that the incumbent council of the IPHC as elected on 21 March at Jerusalem was properly and duly constituted for all purpose, and the incumbent executive committee elected by that council was properly and duly constituted for all purposes. So we agree, and that's per the Constitution, of course, that the council runs the church per the Constitution, and that an exco elected by the council makes day-to-day decisions. The difference is decisions together with the council that the 7-year-old exco, without saying of whom it is composed. It may or may not include some of the applicants. We suppose it may or may not include some of the applicants. We simply don't know. The point is this, my lord. If we get the relief regarding who the exco is, or confirmation, we say, of who the exco is, we can indeed go forward, perhaps along the same lines as suggested by the applicant. But this is sought in action proceedings. And in action proceedings, obviously there will be oral evidence, extensively. all of there is multiple items of disputes of fact on these papers, which we pointed out in our notes, all of which will be subject to oral evidence at trial. And that's indeed why we've launched the action proceedings. We want to consolidate everything, have the oral evidence that's necessary, and create a foundation. Now, in point of fact, I'll point out that your Lordship raised a question which we say is pertinent. Why have the applicants here not taken the opportunity to join in the fray, where they may achieve the objectives they seek in reuniting the church, subject to the oral evidence that is necessary? We in fact invited our learned friends to join the action proceedings, and they refused. My learned Julia will find that letter of invitation and the applicant's refusal to join the action proceedings. Then, just to finish off with the notice of motion, the last two relate to the not at all to the applicants directly. It relates to the bank accounts that have been frozen. We are in a pitched battle with the NPC, who we say have quite illegitimately obtained the unfreezing of the accounts and have drained the account of at least some of the money. Separate issue altogether. Turning back to our invitation to join the action proceedings. If one refers to 001-7,
Apologies, my lord. This is what I referred to in the beginning of my address, that it is not evidence under oath, it is merely correspondence, and that I requested that same be disregarded as no Rule 65E application was brought to introduce this as well.
I take the point, Ms. Pereira.
As
Mr. Osborne, I'm not sure what the value is of this. If it's not under oath.
my lord, our learned friends, with respect, had an opportunity to contest what we say is their correspondence in reply.
But you can't just put papers up. That's the problem with case lines, is people just put paper up. So is it really relevant, Mr. Osborne?
It's relevant only insofar as your lordship has made the point in terms of the final element of interdictory relief, alternative remedies. The alternative remedy is to do the obvious thing, which is to join. Let me not even rely.
I hear what you say. Look,
they would and should have known. In fact, they did know. I don't think it's denied. They did know that the action proceedings were going on. They had every opportunity to join, whether we invited them or not.
Yes.
We did, but that's not the point.
No, you're right. I think it's common cause that there is an action to resolve the matter once and for all. Applicants can join if they wish or not. The question is, how does this relief resolve this problem?
That's precisely our point, my lord. Just one factual item that I want to mention, because I'll forget about it if I don't address it now. Then we'll get to the eliminate points. That the first applicant, Mr. Nwapia, chose not to attend the meeting of the meeting of the council and the executive committee in January of 2017. And in the papers, your lordship would have seen that a coterie of members of the council sent a letter to the council on the very morning of the meeting, saying they would not attend because their safety was not guaranteed. Fine, let's leave that aside. But My learned friend is fundamentally mistaken in that regard, if I may say so. Because in fact, Mr. Nwapia did attend that meeting. He wasn't part of the group that refused to turn up. And may I refer, Your Lordship, to record 006-187. Does Your Lordship have
Yes,
that?
he's right at the top. Elders appointed as council members.
That's right. So far from boycotting the meeting, he showed up and he was indeed elected. Now, one may notice that he was elected to the council. He was not, however, elected to the exco. And one sees that at record 006190. Now, to go back then to the eliminate points, and my Lord, our hope is that if the court is persuaded by our eliminate points, it may not be necessary to traverse the rather complicated disputes of facts which are everywhere here. Our eliminate discussion begins at, in our heads, at paragraph 69.
That is 00.
That is, I only have the...
Okay, let me just try and get there.
pages.
Just give me a
It's
sec.
33. It's 13-33.
Yes.
Firstly, we say the applicants are not vested with standing. Their claim to standing is premised on Section 38C of the Constitution and their membership of the Church. Yet, as we have alleged, they are no longer members of the Church, of the IPHC. And as we have seen, we've made that allegation. And we've made the allegation that custom, albeit not the Constitution, but the custom of the Church, long-standing custom of the Church, is that defectors may be admitted back into the fold by means of a forgiveness ceremony. Now, this has often happened in the Church's history, which has been sometimes practiced. Now, as Your Lordship has noted, one is met with one of the many bare denials in the papers. That's the first item. The second item is, again, this is susceptible, of course, to oral evidence. Given that on our version it's a practice or a tradition, this is something that, as to which oral evidence is clearly appropriate. So our first point about locus is we say they are not members. Our second point is, and we've cited authority for this, the burden lies upon he or she who claims to be a member of an organization to prove that. And our case authority for that is Equity Aviation. A decision of the Labour Appeal Court, and it's at bundle 181. Oh, forgive me, we haven't in fact handed out our bundle.
Thank you.
This was, as the fact that it's in the LAC suggests, a labour dispute, and the question was about membership of a union. Her ladyship, Kampepe, as she then was, writes, and in this, she's one of three judges, but she's concurred in by the other two members of the bench on this issue. And it's a simple point at 138. It is plain that as individual employees were relying upon the existence of their membership, they bore the onus of establishing that their application for membership had been made and considered. And then turning the page, there's a statement, a straight-up statement that the burden lies upon them overall to demonstrate membership. I'll mention, while my learned friend finds that this decision was reversed on other grounds in the Supreme Court of Appeal, and we've attached that judgment at bundle 199. That, we say, is of no account, my Lord, because the overturning of the appeal did not turn on the question of membership. It was accepted that indeed they were not members. The SCA found, however, that notwithstanding that they were not members of the union, they were nonetheless entitled to make representations to the company in the context of strike action. So that's all by the way. Back to Justice Kompepe's language. At para 138 of the judgment, which is bundle 181, to read the first sentence, it is plain that as the individual employees were relying upon the existence of their membership, they bore the onus of establishing that their membership had been submitted and considered in terms of the Constitution. He who avers must prove. So that's our second contention, for lack of standing. They haven't met their burden of proving membership. They would have had they had the opportunity in the reply to say, well, yes, we are members. Here's when we joined. We went to this particular parish or congregation. None of that. Then the lapse, we say, of membership by desertion, so to speak, is dealt with in para 70 of our heads. We need not detain ourselves with that. Then the applicants have a second basis for alleging, well, actually a third basis for alleging standing, and that is section 38D of the Constitution, which has to do with a public interest. They claim to be representing the public interest, presumably in the internal affairs of the ITHC. Now, we respectfully say that's wrong. Firstly, if one takes a very broad, we say an overbroad interpretation of public interest, this creates the unfortunate situation where a church which is given autonomy in the Constitution and where entanglement is discouraged, it gives the opportunity for people to come in from the outside who haven't proved their membership, say there's a broad public interest in the proper functioning of the church. We say that this is a circumstance where public interest should not be interpreted that broadly. And then we've said, aside from that, at para 72 of our heads, which is page 34 of the bundle, we've quoted Judge Cameron in Giant Concerts versus Ronaldo, citation at footnote 71. Justice Cameron, Cameron J. wrote that under 31 there is no broad or unqualified capacity to litigate against illegality. Something more must be shown. Then, as I think my learned friend mentioned, there's a separate argument on locus standi with respect to the first applicant. They say he has standing inter alia, over and above everything else, by virtue of the fact that he's a member of the council appointed under Collipan's order of 22 November 2016. And that's of course correct. We've just seen the listing that shows that he was a member of that council. Here's the problem for our learned friends though. He also says that that council became defunct in, I believe it would be October 2018. That's his contention. The council is defunct. How then can he claim membership on the basis of an entity that on his own version is defunct? That's our first...
Sorry, is this in the applicant's papers? Where do I see that in the founding affidavit?
In the founding affidavit...
I do recall it, but I don't remember where it was.
And their claim that he is standing by virtue of his membership.
Yes.
If I may.
Of the council. Sorry to interrupt you, Mr.
Yes, of course. Yes, I'm much obliged for my learned friend for the third respondent. Well, first of all, here's a claim. Para 6, which is at record 00614. Final sentence, I was appointed as a member of the council of the IPHC on 12 January 2017.
Yes.
That's the claim we've already seen.
Yes.
Now, your Lordship asked in particular where he claims standing on that basis. Well, I wonder if we might ask my learned friend whether that is indeed that position. I'm sure it's here.
I don't recall, but anyway, Ms. Pereira, is that your case?
In our reply, paragraph 19, and I'll read it for the court, my lord, it says, the applicants have locus standi to bring this application. I'm a priest and a member of the council who was appointed pursuant to the order of Collipan J. The second to 12 applicants are members of the IPHC and who are able to attend services of the IPHC for the reasons fully stated in the founding affidavit. They intend to resume attending services and the sermons of the IPHC once the case of violence caused by first to third respondents has been resolved through this application.
Yes, but I think the point is,
whether we are
is it common cause that new council is currently appointed?
My lord, we are not saying, we are saying
like
that they were not constitutional.
That clarifies that. Thank you.
As it is the court.
Mr. Osborne, I think that clarifies that. So there have been new councils appointed, but they're not constitutional according to the applicants.
That indeed is their claim.
Yeah. Thanks, Ms. Barrera.
Now, if I may, turning to our second eliminate point, which is set out at paragraph 75 and following of our heads. And that's 30. With two non-jointed points. The first is something again that's been alluded to, is a failure to join the executive committee, the very executive committee upon which they rely. Now it's interesting to see in the founding affidavit, one finds at 00618 of the founding affidavit, the first respondent is the exco appointed at the special general meeting of the elders 12 January. By the way, that date is wrong, it's not 12 January. It's in fact in February, but we'll get to that. Now, if one then turns to the heading of the case, one does not find the Executive Council cited, and obviously they haven't been served. So that they were aware of the need to join the Executive, they simply overlooked the need to do so. Or, I'm sorry, they did not.
So the fifth respondent is the exco, but you say they haven't been served?
Well, I can't say with certainty they haven't been served. What I can say with certainty is that they are not listed on the front page of the notice of motion as respondents.
Yes.
I assume therefore they have not been served. Now that is in itself fatal because of the obvious interest that the exco have an interest which is effectively acknowledged by the applicant. But then we also say that what's also fatal is the non-joinder of the NPC. Now the NPC, just to clarify, we have four respondents here. We have Michael Santlana, first respondent, being the spiritual head of the fourth respondent, being the International Pentecostal Holiness Church. Now they of course say he's not the spiritual head or he's illegitimately there, but anyway, that's our version. Second respondent is Leonard Modise, who is the spiritual head of another faction altogether. One of the two Modise brothers who are jostling for the position. He has elected not to oppose and he's not sitting in court today. Third respondent is the other Modise brother who is in court, and he claims to be the spiritual head of the church, but not the church as the applicants and ourselves define it. The applicants and ourselves agree that the church is that body established and subsisting under the 2007 Constitution.
The voluntary association.
Indeed. The claim here, or the position taken by the third respondent, is that the real church is an entity which is an NPC, which was founded in 2003. That on his version, and we'll no doubt hear more from my learned friend to my left, that on his version is where all the action is. and that we, the voluntary association, we being the fourth respondent, are usurpers or imposters, whatever we want to use, that the voluntary association became defunct in 2003. It's the NPC that is now the church, of which it so happens the third respondent is the spiritual leader. Now, we've contested that, of course. We've said that the NPC is essentially a non-entity. It's formally registered. We say it's non-functional. Nonetheless, we also have to acknowledge that if it exists, it has a direct and substantial interest. Now, my learned friends say we're contradicting ourselves by having taken the position consistently that it's not the church, but saying it has a direct and substantial interest. But obviously, for purposes of joinder, my learned friends should have accepted that they have a claim, and that if they're right, then it's all over. They're out of court, and so indeed are we out of court, because they are the real church under their articles of association. So that, we say, is a fatal non-joinder for law. Then we have the delay point. Now, delay is not strictly an in limine issue, as your Lordship has pointed out. It comes up in the context of the court's residual discretion whether to grant an interdict. So, could I be given a leave to turn to that? Although it's out of order, as it were. But our position is that if they indeed have unduly delayed, then they are out of court. We need not consider anything else.
Whichever way suits you, Mr. Osborne.
I should say that our learned friends also have a authority point. They say that the person who instituted this litigation on behalf of the third respondent does not have Rule 7 authority. Now, we've dealt with that quite extensively in our heads at paragraphs 79 and following. As I say, it is extensive, and I don't think it's a worthy use of the court's time to belabor that for many reasons, but one reason is, as part of the documents we had entered this morning, is a ratification by the NPC and that is to be found at that too, we'll get that reference.
I don't recall seeing a Rule 7 notice,
That's our other point. There's no Rule 7 notice.
but that's what has to happen.
And yes, and the authority for that is in our heads, ESCOM versus Soweto City Council, Justice Brunt. And
You can't just raise it. You can't just raise it in your papers.
Yes, indeed so. Well, yes, of 042-3, I'm told, is the ratification. Then on to delay. We've headed that, or dealt with that under the court's residual discretion, which is paragraph 122 and following, the last section of our heads. And the last two digits of the bundle number are 53. Now, before looking briefly at the relevant law, may I ask the court's attention to the timeline that we handed out. I doubt that our learned friends will object. We have, in the third column, provided the case lines reference for each of these events. Item 1, we need not detain ourselves on that. It's common cause that prior comforter was deceased on 9 February 2016. A month after that, it was a month after that that the schism within the church began, when Cheshipo Modise, instituted proceedings claiming that he was the comforter. And that's item 2. Then at item 3 we have the various Colipin orders which were granted under the case number of the claim to the throne. And our point, not to belabor it, is that if the first applicant was worried about schism and uncertainty in the church, his opportunity came as early as 2016. Because the uncertainty was there, clearly, and it led to ongoing litigation, which, of course, our learned friends could have joined. In any event, we went already through the meetings in January and February 2017, in which both the council and an exco were elected. That's item 6 and 7. It was on 27 October 2018, item 8, that Mr. Modise, the third respondent, came on the scene, having initially made common cause with his brother, supporting his claim to be comforter. He then emerged and claimed that no, he was the comforter. And one of his acts was to, on 27 October 2018, invaded and took over the seat of the church's power at Silo. That led to an eviction application, and that eviction application is one of the 3 items that has been subject to consolidation.
Yes. Mr. Osborne, I don't want to interrupt you unnecessarily, but I know this
Yes.
timeline. My question is, why so long?
That's exactly right. I'll name only one further.
Of course.
That's 2018. 2018 was the apocalypse as far as the church is concerned, because it was then that the invasion of Silo took place. Secondly, during the invasion of Silo, there was allegedly violence. In fact, no, I won't say allegedly violence. We are happy to admit that there were incidents of violence. Our contention is twofold. First of all, our position is, and this is not denied, that the IPHC was not the perpetrator of the violence. It was Leonard Modise's faction that invaded the church. Again, it's not disputed that it was they that invaded.
The fact of the matter is there was violence.
Indeed. So that is named as one of the irreparable harm considerations. Violence in the church. First dissent in the church and then violence. The fact, though, is this happened in 2018. The opportunity to come to court was then, 2018, 6 years ago. I need to say no more, I assume, on the delay. And we've cited in our heads cases on delay, which are numerous, but one we cite amongst many is at para 23, National Council of Societies for the Prevention of Cruelty, and the SCA decision of 2008. What we've chosen to focus on, though, because it's more closely resembling our case, is a case called Juta versus Legal and Financial Publishing, footnote 123, in which the delay was maybe 3.5 months, from 14 March 69 to 17 December 68. In brief, this is a Copyright Act. Juta was complaining that the respondent was stealing its material. They became aware of that in 68. They did nothing until 14 March 69. And the whole sequence is in fact quoted in the National Council of Societies case, where they quote, and the quote is there, if one bears in mind the long delay for which no explanation has been given, as far as back as December, the applicant, being Juta, had numerous clear cases of copying in its possession. It did nothing for short of 4 months. If that's considered excessive delay for interim relief, we need hardly say anymore. Then Erasmus says, we cited that in footnote 124, an interlocutory interdict may be refused if the applicant has delayed long before applying. Since an application for an interdict, pendente lito, is from its very nature required, requires maximum expedition. And we've cited the passage in Juta. Then the prolonged delay has not been without consequence, in the sense that the church has operated on our version. It's had regular elections. It's, as conceded, the largest in South Africa. Settled expectations and practices have developed. There have been tens of thousands of marriages, for example, under the aegis of this church.
None of this is in your papers, though, I don't think.
It impacts in the sense that there's been prejudice as a result of the delay. If that moved quickly, we would not have had this pattern of third-party expectations. And then we've cited other cases involving acquiescence, at paras 128, 129, another church case in which the director's decision was taken. The directors that they'd been improperly excluded did nothing for a couple of months. Court said, too late. You should have raised your objection there and then. I need not pursue that, I assume, at all. Now, my Lord, we seek guidance. Would it be expedient to obtain an answer on our eliminate points first, or should I proceed to the facts?
I think we should do the same as Ms. Barrera. I asked Ms. Barrera to do, deal with the merits of it as well. I think you heard, Mr. Osborne, where my concerns lay. First one was prima facie right. Well, is there a prima facie right in the first place? If there is no locus standi, then there can't be any prima facie right. If there are members, where does that leave us then? That's one of my concerns. Irreparable harm. What is the irreparable harm? Given that 6 years has passed.
Yes. My Lord, all of that is dealt with in some detail.
In your heads, yes.
If your Lordship is...
you don't have to belabor it, Mr. Osborne, unless there's some specific aspects you want to raise.
Well, let me say this, because this is important. The argument for irreparable harm, we've already covered some of it. The violence, single incident in 2018. The dissipation of funds. We've dealt with the fact that the accounts are frozen. And then thirdly, we need to talk about the rights that are at stake. Now, it is alleged at some point the point is taken at some stages that this is a matter of freedom of religion. The applicants are denied their freedom of religion because it's not open to them to attend the church of their choice. That's the argument. And in that regard, we have a couple of responses. First of all, nothing is said about anyone being excluded from their church. In fact, we've said that all are welcome. And we do not set up, the church, I should say, does not set up preconditions. You've got to swear an oath of loyalty to the first responder. Now here again, here's an opportunity, a perfect opportunity for oral evidence. We need some of these applicants to come to court and say, I attempted to enter the church on this Sunday. I was excluded involuntarily on the basis of my infidelity to the comforter. That's our first point. The second point is that it's quite peculiar to read it. The applicants, having said that their religious freedom has been violated, also say that there's no issue of religious freedom in this case. If I may be excused. In our heads, we've quoted the relevant passages in their heads, in our heads. And that's at paragraph 38 of our heads. My learned friend is looking for that. But in any event, I'm not sure really what's left of their argument if they say freedom of religion is not implicated. I suppose they left with a position where they say, well, the Constitution, in fact they suggest that it's the Constitution that guarantees them the right to enter the church of their trust. We've cited in our heads that the freedom of religion has been interpreted to mean not only the right to participate, but also the right to exclude. And for that is the famous case of Taylor versus Kirstad, which we've cited in our heads at 38, and it's bundle 37. And this is a case in which an individual, the applicant, had been excluded from a shul in Johannesburg on the basis that the leadership of the shul had deemed him to be a heretic, or whatever the term is. And the court made the point that non-entanglement includes not presuming to instruct a congregation who or whom they are required to welcome. Then, finally, just to deal briefly with the elements. We've covered much of this. The prima facie right. The reference I was looking for regarding freedom of religion is 06-55. And 0655 para 147.3. There's an insurgence of purported IPHC branches across the country. These are being opened by members who defect the factions of First to Third. Now they are exercising their freedom of religion by opening their own churches. Some of these are opened by IPHC members who have been sitting idle at home, awaiting the resolution of the leadership dispute. Now here's the point with respect. Whilst we do not intend to suggest that people cannot practice their religion freedom, their religion freely, we simply require that our members conduct themselves in accordance with the IPHC Constitution. Now that's not the business of the court. and if it is said to be the business of the court, we go to the alternative remedy. Their alternative remedy is first, under the Constitution, something called a disciplinary committee is created. The first port of call for someone unhappy with church affairs is to go to the disciplinary committee, wherein they will presumably seek discipline against the alleged usurpers or deserters, whatever term one wants. Their second recourse is to approach court or to join already existing proceedings. And there's an interesting case, very much on point, that we happened upon, that I'll briefly take the court to, and it's at bundle 28. In fact, the case opens not at 28, but at 21. Methodist Church of Kings Williamtown versus Mamkeli, 2024 case. I refer only to, and by the way, this is a church, this is a case remarkably similar in many ways. We also have system of contestation of leadership, parallel disagreeing councils or differing councils, etc., etc. And alleged intimidation. You'll recall that one of the allegations is that applicants are intimidated from entering the church. Similar complaint made here, and it's dealt with in paragraph 28 of the decision. And it deals with adequate remedies. Firstly, the allegation was, well, you could have reported it to the police. Now, the court properly dismisses that and said it's hardly a remedy to wait for the NPA to bring charges. But secondly, the court points to the Protection from Harassment Act, Act 70 of 2011, which precisely, amongst the many other protections it grants, is protection from intimidation. I'm sure there's many other alternative remedies, but just to mention one that happens to have been invoked in a rather similar factual setting. Then the Lord finally, if your Lordship will permit, there's a long list of factual disputes that we say are subject or would necessitate oral evidence. And your Lordship will know that under 65G, Rule 65G, a court may dismiss an application altogether if it's found that the applicant should reasonably have foreseen that disputes of fact that could only be subject to oral evidence will arise. And that's what we say, with respect, your Lordship should do in this case. I have not dealt with the applicant's lis pendens argument. I simply refer, if your Lordship permits, to paragraphs 84 and following.
We have to put pay to that.
I'm sorry?
It's not the same parties.
Yes,
in various matters.
Indeed. Then, well, again, I'm not going to belabor the factual disputes. We set that out exhaustively. We set out the various elements exhaustively, and we've mentioned those. If I sense that your Lordship's patience is
not at all
being tried.
Not at all.
I'm
not the one standing here with a robe in this hot court.
So, my Lord, unless there are any other particular items that your Lordship is not satisfied with our heads,
I'm grateful for your heads and yours, Ms. Barrera. They were pretty comprehensive, and yours, Mr. Mpilo.
As it pleases the Court.
Thank you. Mr. Mpilo?
Coming at the end of the proceedings, I'm covered mostly by the points that have been made by my learned friend for the first and the fourth respondent. Of course, there are there are things that we differ with them, and I will address those. I will not deal with everything that we have raised in the heads of argument in the late. Safe to say, on the issue of local standing, the third respondent takes the point as well in the answering affidavit, and then we, without wasting your lordship's time, we will align ourselves with the submissions made by our learned friends who first to both responded that the local standing has not been established.
I understand.
And on the second point in limine that we take, I mean the first point, I think that is our point actually, in the ninth joiner of the MPC. The relief that is being sought in these proceedings, obviously Manoki, is the one that will take away the power of the IPHC from the directors in terms of the constitution, I mean, not the constitution, in terms of the articles to the committee suggested by the applicants. That's one thing. And the second thing is